I think I'm not getting any more alerts, so I'm going to at least start the intro to get us started. My name is Henry Sommerfeld. I'm the president-elect of the UB Law Alumni Association's Gold Group. I want to thank all of you today for attending our CLE titled Nuts and Bolts of Asset Purchase Sale Transactions. This is one of many presentations we've done in a series of virtual programs through the Law Alumni Association and the Gold Group. And it's a service for our alumni and the law student at UB. If you're interested in attending other upcoming webinars and CLEs, you can register on the UB Law School website, which is law.buffalo.edu/alumni events. You can also listen to past CLEs and other webinar recordings at no charge on our new alumni education webpage, which is also located on the law school website. To get discounts and select free 1-hour CLEs, please consider becoming either an annual or lifetime member of the UB Law Alumni Association. Finally, I'd like to thank the Gold Group sponsors who have helped underwrite the costs associated with these events and many others that we do. Those sponsors are Chicago Title, Council Press, Equitable Advisors, Jack W. Hunt and Associates, and Precision Resolution LLC and Paramount Settlement Planning LLC. We're grateful to each of you for your continued support of what we do. Just a few housekeeping matters that I'll point out. You will be muted during the course of the presentation. If you have a question, use the chat function, and we will try to address those cumulatively at the end. I heard when I got on here that they want it to be sort of an engaging presentation. So to the extent they're going to entertain questions throughout and not at the end, I'll leave that to our presenter today. At some point during the course of the CLE, there will be a course code that will be announced, and you will need to make sure that you catch it. You'll need it for your online verification to get credit. Make sure that you go online and complete the attorney verification when the program is concluded. There'll also be an opportunity for you to provide feedback of this presentation. So we ask that you do that on the program evaluation form. With that, I thank you all again. I'm looking forward to this discussion, and I'm going to turn it over to my colleague and board member, Andrea.
Good afternoon, everyone. My name is Andrea DeLulio, and I am a graduate of the law school and a member and past president of the Gold Group. Now it is my great pleasure today to introduce to you our speaker and my colleague, Anthony Eugeni. Anthony is a partner at Woods Oviatt Gilman in the firm's business and finance department, and he is a member of our mergers and acquisitions group. He concentrates his practice in the area of mergers and acquisitions, business formations, and representing borrowers in debt-based finance transactions. Mr. Eugeni has also represented clients in connection with the drafting and negotiation of a broad range of agreements, including manufacturing supply agreements, shareholders agreements, operating agreements, license agreements, non-competition agreements, non-disclosure agreements, and consulting agreements. He represents both privately held companies and publicly traded companies. Anthony received his BA from the University of Notre Dame and his JD from UB Law. He has also passed the CPA exam. Mr. Eugeni is very active in both the Niagara Falls and Lewiston communities. He's a member of the board of directors and a past president of the Niagara Falls Boys and Girls Club, a member of the board of directors of Mount St. Mary's Hospital Foundation in Lewiston, and a member of the board of directors of Our Lady of Peace Nursing Home in Lewiston. I also like to point out that today is Anthony's birthday, so we are all very grateful that he was willing to donate some of his time on his special day to us. So without further ado, I turn it over to Anthony Eugeni.
Thank you, Henry. Thank you, Andrea. Hello to all the attendees. Thanks for attending on this sunny Thursday in Buffalo. It's always a crapshoot in April. As Andrea mentioned, am another year older today, and I will show my age by saying that when I agreed to participate and present, I had assumed it was an in-person presentation, and realized when I was told 2 weeks ago that it was virtual. This is my first virtual presentation. It's honestly a little strange to me, so please bear with me. As Henry mentioned also, I prefer to have this be interactive. It's better for me and I think the group if there's questions that come up, they can be asked and I'll answer and have this be more of a conversation if possible versus just me presenting, especially me to a screen. So that being said, I have been practicing corporate law since 1991, and I use that term obviously, very loosely. Corporate law, I think, is a word used in general, but is meant to cover, representing businesses of all different types, corporations, LLCs, partnerships, etc. I always tell people, including my mother, that what I do is never seen on TV in a TV show. There's no TV shows about corporate lawyers reading contracts, because who wants to see that? But basically, I've been engaged in, the practice of corporate law since 1991. And, what I do involves from time to time sales, purchases of businesses. So today's presentation is meant to be a somewhat basic level, high level presentation on the nuts and bolts of asset purchase sale transactions. Again, this is meant to be really for the inexperienced or the non-corporate attorneys who might hear these terms, might hear these, different phrases, and not meant for the, people of my age who've been practicing since, the 90s. That being said, if anyone has any questions, feel free to ask, whether simple, not so simple, basic, not so basic. So that being said, I'm gonna follow the outline to some degree, and starting with, general terms, there are three basic structures for buying a business. And from time to time, I'll refer to the business as the target, like a cap T target. And you keep hearing, or might hear the phrases, asset purchase, stock purchase, merger, and we'll go through those. Now, when I do say, and start off with, say, a stock purchase, that is assuming that the target is a corporation, because a corporation's equity interests are in the form of stock. And I will typically think about a corporation being the target today, but understand there are all other kinds of entities, LLCs, limited liability companies, general partnerships, limited partnerships, etc. Each of those have different types of equity called membership interests or partnership interests, but I will, use loosely today the word stock to mean ownership interest, but here for a corporation. So in a stock purchase, you have the target, which is the company, with shareholders who own the company. And in general, when you think of these concepts today, think of simple concepts, and they really do apply to the larger type entities and vice versa. So I'll start with where you have a stock purchase. Think of you buying one share of Apple, and you are a shareholder of Apple. You own stock in Apple, and if you then go to sell your share through an exchange or otherwise, you are selling shares and someone's buying your shares. The same holds true where you have a target that might have one shareholder, 5 shareholders, or more shareholders. And a stock purchase is where the ownership changes of the target, but the target itself, the entity itself, is in no way impacted by the purchase and sale of shares. Whatever the target owns by way of assets or owes by way of liabilities is unchanged. And in general terms, any contracts held by the corporation, any debt, known or unknown, again, stay with the corporation. All that's changing is the ownership of the stock. A merger involves typically, an entity will say A into B, where B survives, B into A, where A survives, or A and B say consolidate to form C or a different entity. And in general, a merger means that two entities are combined, consolidated in some way, and the resulting entity is the sum of the two entities that were involved. And again, I'm going to date myself that in 1998, there was Daimler-Benz Corporation, the manufacturers of Mercedes-Benz and Chrysler in the US, and they consolidated, merged into one entity, becoming Daimler Chrysler. Now we have the asset purchase structure, the focus of today, which is meant to be where before we had a stock purchase, the target with the shareholders, where shareholders change. This is an asset purchase where you have a seller entity and a buyer. And I'll start by saying that, again, I always like to think of a more simple example. Asset purchases happen all the time. When you go to buy a car, that's an asset purchase. When you buy something off of eBay, that's an asset purchase. You have a seller, you have a buyer, where the seller is selling to the buyer certain, hopefully well-defined goods. So that concept applies in a larger view or transaction where an entity, say a corporation, is selling assets to a buyer. And by contract, the assets are agreed upon, and what else is being bought, sold, assumed, liabilities, etc., is a matter of contract. I guess in general, very, very, very high level, from a liability standpoint, buyers prefer asset purchases. Again, for the most part, the starting point is buyers want to engage in a purchase of assets, I'll say, most often for insulation from liability. Just like I buy a good through eBay or buy a car, I am not, as the buyer, automatically responsible for the liabilities of the seller, whether known or unknown. That when I buy something from someone else, I'm not responsible. And as lawyers, when you have a client who wants to buy a company, you always worry about the unknown, the liabilities that are held by or incurred by the seller, and you don't want to become liable for known or unknown liabilities, i.e. buy the asset, pay money for it, and move on.
Can I interrupt you right there? Is it ever the case where the buyer, instead of paying cash dollars for the assets, pays in stock of the buyer entity? And if that does happen, how does that impact the buyer's liability in the deal?
So you're saying that the seller will take on shares of the buyer and become an owner of buyer?
Correct.
Correct. No, and that is done, not uncommon for, again, this is a different topic for a seminar, but that's in general called rollover equity, which can lead to very efficient tax results. But again, to the extent that the buyer becomes an owner of some percentage of the equity interests of the buyer, seller gets the equity interest of the buyer, the buyer is still buying only certain assets. You have still the separation in theory between the seller and the buyer, even though the buyer becomes a shareholder. Seller's a shareholder of buyer. There's no intermingling here if T's are crossed and I's are dotted. Does that make sense?
It does, and we have a follow-up question here in the chat, which is, are there any liabilities which pass to the buyer by operation of law, even in an asset transaction?
The answer is yes, or at least potentially yes. I'm going to say by operation of law, by statute. The largest, say, potential assumption of liabilities by operation of law is in the sales tax area. That when you're buying an asset purchase from a seller who's required to withhold and remit sales tax, if you don't go through the necessary filing and notice to Department of State Taxation and Finance, if you do not let them know about the purchase of the business, and give the state time to look into the sales tax payments by the seller and then get a clearance letter saying, go ahead and buy. If you don't go through that process, a buyer is liable for the unpaid sales tax of seller. And in that vein, it gets a little tricky because there's a famous case, and I'm in the ballpark here, back in the 90s, where a restaurant owned operations of a restaurant, but leased real property. So it operated a restaurant at a leased real property location. It had also owned, I think in a different county, a piece of vacant real property. A buyer bought the vacant real property from the restaurant corporation, didn't go through the process of notifying the state and getting a clearance letter, and that restaurant had a lot of unpaid sales tax that buyer of vacant real property became responsible for. So, one of the things I ask for in any transaction, even buying real property, is representation that seller isn't required to collect or remit sales tax. Now, apart from operation of law under statutes, there's case law, as Andrea knows and can touch on when appropriate. At the extreme example, a buyer of assets can become responsible for unpaid liabilities of seller, where they are, say, an alter ego or continuation of the seller, which is, all under common law and case law. And again, in general, at a high level, to the extent that the buyer buys assets after the closing, does not use the same name with the same phone number, at the same location with the same management and the same president, absent some extreme set of facts, the buyer should not be responsible. But it isn't, it doesn't mean that a third-party creditor still wouldn't bring a claim trying to claim that the buyer isn't responsible for the unpaid liabilities of the seller.
And that scheme you're referring to that's in the case law is referred to as de facto merger often, correct?
Correct. Yep.
So when those circumstances are present, the operations are out of the same facility, the employees are the same, there's ownership that's crossed over between the two entities. So sometimes the court will find that the buyer is liable for some of the debts or liabilities of the seller.
Exactly.
We have another question specifically about how long it takes the state to process the documentation to convert the ownership over and to issue the clearance letter on the sales tax piece.
They're actually very good now. Again, if it matters, back in the 90s, it was hell. It was probably 3 months. Now the bulk sales unit is very, or at least more efficient. I think worst case is a month, but the past few I've had have been 2 to 3 weeks. I think it was a little bit longer last fall, obviously with holidays around Thanksgiving time, but they have become much more efficient. So again, to round up, I'd say, a month, but I think 2 or 3 weeks is, even 2 weeks is a good guesstimate right now. Okay. So kind of being back to the primary pros of asset purchases from buyer's perspective. First one is flexibility. A buyer can pick and choose, i.e. cherry pick what they choose to buy. Likewise, a seller can choose what they decide to sell. Again, just like me as a person individually who has assets, I can decide out of all of my assets to sell just my car. Likewise, businesses have certain assets. They have certain, items they own. They're tangible, intangible, that can be bought and sold. Phone numbers can be bought and sold. Email addresses can be bought and sold. Contracts can be bought and sold. Customers can be bought and sold. Then on top of that, equipment, inventory, etc. So you can pick and choose what's being bought specifically. From, again, the buyer, a main point is insulation from liabilities, as we discussed. and not to get too much into the, tax weeds here, but when there's an asset purchase, the buyer pays a price for those assets that is then considered to be basis for income tax reasons, and then can lead to depreciation and other tax benefits. To contrast, where you have a stock purchase, you have the corporation has assets that are being depreciated. As shares are bought and sold, there's no change in that depreciation. There's no change in write-offs. When a buyer buys assets, that buyer pays for them at the closing and or over time. And then likewise, they're able to typically depreciate and write off certain assets as time goes on. There's write-off periods for goodwill, intangible, for equipment, real property, etc. So there tends to be a tax advantage for buyers in asset purchases. Cons of asset purchases from a seller's perspective. Again, without getting to the weeds too much, there's potential double taxation. I'm guessing most people have heard of S Corp and C Corp. And by way of background, S Corps have one level of taxation. If you're eligible to be an S Corp under our tax code, the corporation itself, you have the corporation that has shareholders. The corporation itself doesn't pay income tax. The corporation itself will have income tax from its operations that then pass down and flow through to the owners, where the owners pay the tax on the income tax of the taxable income of the corporation. And S versus C understand that an S corporation is no more than described in subchapter S of the tax code, compared to a C corp, which again is subchapter C of the tax code, which has two levels of taxation, where a C corp is going to sell assets. The corporation itself will pay tax. So say it sells for $100, a certain asset, pays tax on that of say 40% or $40, leaving $60 in the corporation. When the corporation then gives the money to the shareholders, we'll assume here it's one shareholder, the remaining proceeds after tax of $60, then the shareholder pays tax on that $60. If we assume the same tax rate, it would be then the owner will have $36. So you go from 100 to 36 with double taxation versus 100 to 60. Then another potential con of an asset purchase involves contracts. To the extent a corporation is the owner of one or more valuable contracts. I had this case, a matter a few years ago, where a corporation had a long-term contract, 4 or 5 years, to be a supplier, vendor, somewhat sole source to Home Depot. And for the asset purchase, if the buyer wanted to buy the contract, Home Depot had to consent. So there might be valuable contracts that cannot be transferred without consent of a third party. In a stock purchase transaction, where the corporation, the target, is the owner of the contract, if the shares change, the contract is still between the target and, say, Home Depot. Now, that being said, there are, very well-drafted contracts that specifically say, and they must say specifically, that a change in the ownership at all or above a certain percentage is a deemed assignment and requires consent of the other party. But again, one of the reasons why potentially a seller might want to do a stock deal, because of the easier transferability of a contract, and so for the buyer. Any questions? Okay. I list some typical assets being bought and sold. And again, this is just a list of potential assets. There's more out there, obviously. And again, these assets, buyers can pick and choose along with sellers what they want to have bought and sold. Again, in a stock purchase, there isn't really any ability to cherry pick. It is you're buying the entire corporation, the whole kit and caboodle, with all assets and liabilities. We'll go through an actual purchase agreement. And again, as far as, main lingo, asset purchase agreement, us corporate people refer to those as APAs. Stock purchase agreement, SPAs. So you hear APA, SPA, asset purchase, stock purchase. For parties, buyer and seller, and I'm going to assume here we have two entities, one seller entity, one buyer entity, and where you have a corporation seller that is selling all of its assets, selling everything, you presume that at the closing, seller gets the cash or a promissory note or a combination, sells everything to the buyer. At that point, that corporation has as assets the cash it received and the note, and that's it. Day after closing, when it distributes out to the shareholder or shareholders the cash and the note, at that point, that corporation's a shell. It has no assets, and that's legal. So as a buyer, when seller is obligated to covenant or do certain things post-closing, whether indemnify buyer for liabilities not assumed, not compete, etc. Any obligation of the corporation is in theory on paper, but if it's a shell and the corporation breaches, you have a blood and stone problem where a buyer claimant is suing the corporation seller and they have no assets, i.e., they're judgment proof. So it's not unusual in most asset purchase transactions to have one or more sellers be a party to the agreement individually to back up or backstop every obligation of the seller, or maybe certain obligations. At a very simple starting point, especially with a closely held company, small number of shareholders, you want to have, the shareholders or main people driving the business to be a party to at least agree to not compete with the buyer. Again, if you have a seller non-compete, that does not prohibit, absent the shareholder agreeing to, does not prohibit a shareholder or principal from then competing thereafter. Now, I want to go off topic a little bit, and this is, I don't want to confuse people, but one potential grenade is going to be in the goodwill area. When goodwill is being bought and sold, whether by itself or as part of a larger group of assets, when goodwill is bought and sold, there's a line of cases in New York, starting with Mohawk Maintenance, the Mohawk Maintenance cases, where a seller who sells goodwill to a buyer, the courts have held that goodwill is patronage of customers. And even without a covenant to not solicit customers, so even if the seller doesn't covenant to not solicit customers, formerly of seller, now with buyer, or even if the seller does agree to not call upon, solicit customers for a certain period, even after that period expired, the courts have held that upon a sale of goodwill, a seller is prohibited under common law from soliciting customers that in essence it's sold to the buyer. Now, there are cases about if the customer calls upon the seller, different issue, but at least be aware of goodwill can be a trap. In the Mohawk Maintenance case, basically there's a sale of goodwill. They signed a covenant for a few years. The few years expired. They start calling upon customers. The buyer sued and the buyer won. Okay.
I have a question in the chat for you. It is, how would the proposed FTC requirements around non-competes affect this line of cases?
I can't say I've read the rule. I mean, as I understand it, and I have not followed it closely. I'll follow it more closely when it's adopted or, looked at by the courts. But, the FTC is trying to have, that's, I think, in the non-compete issue, in the non-compete world, basically make all non-competes, non-solicitations unenforceable. And I think, though, I think it was meant to be by the FTC in the employment context, not in the asset purchase context. But I'm not, I'm going off of a few articles I've skimmed without knowing the details. But again, to my knowledge, FTC rule is meant to cover employment situations where you have a non-compete solicitation by employees, not in sale context. That's my impression. But don't hold me to it.
Fair enough. Jumping back a little bit, you talked about how if the seller sells all of their assets after that deal is closed, they're left as a shell company. Is there any reason that entity needs to continue to exist in shell form, or can it just dissolve and go away?
In theory, there's no reason to have it not dissolve. In reality, or at least in my practical reality, my advice is always to keep the corporation in existence, not dissolve it for 2 or 3 years.
Why?
Because in theory, a dissolved corporation, it's in the statute, can sue and be sued. And the dissolution of the corporation should have no effect on any personal liability of the shareholders. But to the extent it's not dissolved and it still exists, it's easier, I think, to argue, just from a parent standpoint, that the owners are not liable for any unpaid debts of the corporation because the corporation still exists and has no assets. When there's a dissolution, and again, I think the pure case law, I think the pure statute says otherwise, but I think it just gives the wrong or bad appearance when it's dissolved. That's easier to attack the shareholders. I think that not having that barrier in place, not having it dissolved, makes it easier in the practical world to whether it's a claimant and or a judge to use that barrier again and have a shield between the shareholders and the claimant.
Is it common to have the seller agree not to dissolve and to keep the money in the company and not distribute it out to the shareholders in an asset purchase agreement?
Yes, I mean, again, there's other, understand that, and it's a different CLE topic, but when the corporation sells, it's supposed to pay off all creditors before it makes a distribution to the shareholders. That money is, say, held in trust, potentially for claims of creditors, and it's meant to, the corporation is not the corporation cannot just take the money it received at closing, know there are creditors, not pay them, then give money to shareholders, because the shareholders will have then personal liability. The shareholders, in essence, are also holding money in trust to pay off or make sure that creditors are paid. And depending upon the situation, it can be wise to at least have the seller sell the assets, take in the cash, pay off known creditors. If there are potential and or unknown creditors, potential being you're aware of, say, an accident, but there hasn't been a suit yet. You're aware of potential breach of contract, no suit yet. the corporation might want to wisely keep money in there. Again, even for appearance purposes, it looks better when corporations sell and keep money in there for a few years versus paying everything out. That's from the seller perspective. From a buyer perspective, depending upon what they know about the liabilities that they didn't assume, they might require the seller to hold the money, or might require an escrow so they know where it is to pay off potential claims, or potentially, or a combination of all these, pay the price pursuant to a promissory note so they control where the money is. So if there's a claim for indemnification, they have the money in their hands versus the corporation seller hands.
Is it common during the negotiation of an asset deal for the buyer to want to see all of the debts and liabilities of the seller entity?
Not uncommon. I think it depends upon, again, the type of business, the dollars being paid. Is it the entire company? Is it to the part of the company? I'll say it depends, case by case. I won't say all cases, but I also won't say never. Because again, as a buyer, even notwithstanding what even the theory is, as you know, Andrew, in the case we're working on right now, that a client or a customer, vendor of a seller might not be paid out the closing proceeds because of lack of funds, and they don't care. They're suing the buyer anyway, just to try to get a settlement or get a pound of flesh. Really, under even having bad facts, sometimes they don't care. So buyers want to even get a handle on what their risk of being sued post-closing might be, even if they aren't by any means a successor or part of a de facto merger. Okay.
Yeah, I'll take this time now to just let everyone know that the course code is M&A, and I'll put that in the chat as well.
So under page 2 on the APA bullet points, I referred to liabilities being assumed, not being assumed. When I say, insulation from liabilities, if you're the buyer, you can agree by contract to assume certain liabilities of the seller, certain defined liabilities that's possible. Understand that assuming a liability is akin to paying a purchase price or paying dollars, where you agree to pay a debt of the seller that's akin to paying money to the seller that they use to pay off the creditor. Purchase price and payment. When you're a seller, you want all cash at closing. When you're a buyer, you want to not pay all cash at closing for different reasons. 1, cash flow. 2, having some sort of funds to attack if there's a claim for indemnification, etc. The bullet point closing, sign then close, or contemporaneous signing closing. That means under some transactions, you sign the APA and then close thereafter, say a month or 2 after, to get financing in place, to do some more due diligence, etc. The other potential structure is contemporaneous sign and close, where you sign the agreement and then close a minute later because everything is in place. So I'm just going to jump to the form APA that I attached, or at least the version I attached, and this is in the end, APAs take on different forms, different lengths. In typical practical terms, the larger the transaction, i.e. the more dollars involved, the lengthier these are. It's just not practical to have a 70-page APA for a 20 grand transaction. Plus, likewise, conversely, for a $100 million transaction, a 4-pager also isn't applicable. General statement. So this agreement, this was a purchase sale of a decent size market grocery store. One location, privately held. The price was about $1 million, as I recall. A situation where seller is selling its assets, going out of business, etc. So starting off, the parties We have the seller ABC Inc. We have the buyer XYZ Inc. Then we have the husband and wife owners, John Doe and Jane Doe, who are also parties for different reasons. 1.1, purchase and sale of assets. From a drafting standpoint, whether, any contract you want clarity, but it's very important you have clarity here on what's being bought and sold. In 1.1, we have a list of assets. And in 1.2, we have a list of things that are not part of the transaction, i.e. excluded. And practically, you're best off having one of those two buckets be defined as including everything except as part of what's in the other. Where in 1.1, how I have this set up is seller is selling, buyer is buying every asset of seller, every asset, unless listed in 1.2, unless excluded. So the default is if not listed in 1.2, it's in 1.1. Again, conversely, what you can say is in 1.1, here's what's being bought and sold specifically. Then say in 1.2, everything else is excluded. I recall years and years ago, back in the mid-90s, it wasn't something I drafted, but we had a contract where there was a list of assets being bought and sold, very specific, a list of what's excluded, very specific. And then we had a fight over who was entitled to deposits under contracts. So again, you're better off trying to have at least one of those buckets be broad. 1.3, assume liabilities. Again, try as the buyer, you want to be very clear on what's being assumed, if anything. Then we have 1.5 and 6, the purchase price and the payment. In 1.7, the allocation, again, high level comment, understand that when a company's being sold, there's a lot being bought and sold. For income tax reasons, you want to specify the amount being allocated for each of the assets. Because again, we're not just buying and selling one car, we're buying and selling multiple assets. You want to allocate the price over and among the assets to make sure we're all on the same page, buying and selling on the same page for the tax effects. 2.2 and 2.3 are deliveries at the closing. Article 3, reps and warranties of the seller, i.e. the corporation, seller, and the shareholders. Reps and warranties are meant to be things that are said by the seller and the shareholders about the target, the company, the operations, etc. And these become very, very important because a breach of these, and these are important on both sides, a breach of these, can lead to damages to the buyer, can lead to a claim for indemnification, etc. So when I'm on the buyer side, I want to always find out from the buyer, in general, what's important to them, what do they want to know is true, what should be repped and warranted on paper, what do they rely upon in making their offer and determining the price. At a very simple starting point, buyers typically rely upon the information given them, whether by financial information, balance sheets, income statements, tax returns. You want to at least have reps and warranties about the income statements, balance sheets, other statements being true and accurate. Likewise, the tax returns are true and accurate. There's more details there, but want to make sure that we're told. And ultimately, these reps and warranties lead to an allocation of risk between buyer and seller, and who will allocate and take on what risk. For example, for equipment being bought and sold, is that being bought and sold as is? Is it being bought and sold with rep and warranty that it's in working condition, good order? So I think the more you talk to your clients and try to get out of them more information that's important to them, the better off you are. on the buyer side. On the included in Article 3, the shareholders, Jane and John Doe, because this case it was a sale of the entire company. There would have been shall after the closing, so the individual shareholders also repped and warranted these specified reps and warranties in Article 3. I'll point out 3.11 and 3.11, 3.12 employee matters. When buying an entire company by asset purchase, dealing with employees is important. And a very simple starting point, employees of a selling entity presumably have accrued unpaid benefits, whether vacation, sick time, other paid time off. When the employees transition over to the buyer, what's going to happen? Will seller pay them off? Will buyer assume those benefits? Because at least from the employee standpoint, they want to make sure that they get what they deserve, whether from the seller or the buyer. And most want, don't know even the differences, but you want to make sure that this is addressed. Especially from a buyer standpoint, buyers want to make sure they have employees who come over who are very happy, who know what's going on. They're informed of what's going to happen, i.e. buyer might be assuming all the PTO, accrued vacation, etc. In Article 5, these are pre-closing covenants. This is a sign then close transaction. So there are covenants here between the time of signing and closing. No change in the business, maintain goodwill, keep your normal inventory. 5.8 is a reference to the bulk sales tax notice, 1141 of the tax code, of the tax law, New York tax law. This is where there's an obligation for both parties to cooperate. It's a buyer filing, but in theory, there must be, the seller sales tax number must be on the form, so seller must cooperate to some degree in the completion of the form. In Article 6, those are conditions precedent, i.e. things that must happen, whether on the buyer side or seller side for closing. As a buyer, the big one here is typically financing. Will there be third-party loan from a bank? Is that obtaining a loan a condition precedent to closing, i.e. is there a financing condition or not? The other big one is on due diligence. Is there a due diligence contingency? As a seller, you want to have a buyer typically have a buyer due diligence before they sign the agreement to say they're going forward, and have this be binding, or at least not have a due diligence contingency. Again, it's a general overstatement. That's a general typical approach. In Article 7, we have the survivability of reps and warranties, and then indemnification. And again, indemnification itself can be a separate CLE, but typically you have indemnification provisions in these contracts to try to better define or clarify the obligations and also the allocations of risks. If you don't have indemnification language in your agreements, there are still claims under common law for direct breaches, for damages due to direct breaches. But these provisions at least try to clarify, what are the damages or what sort of cost and expenses can be, obtained by the buyer for a breach of a rep and warranty or covenant by the seller. Article 8, post-closing covenants. Again, the big one here is non-competition, non-solicitation covenants. Back to Mohawk Maintenance, if I'm the buyer attorney and I'm aware of the line of cases for Mohawk Maintenance, I'm going to tell my client, understand that this seller could in theory solicit the customers. I'm sorry, I have it backwards. I'm sorry. If I am the seller and I'm signing a non-solicitation for a certain period, I'm telling my client that understand that if that period expires and I have sold goodwill, that you seller will still be prohibited from calling upon the customers even after expiration of that period. And we'll ask them, is that okay? Do you have any intention to get back in the business? And then potentially comes a negotiating point or a negotiating topic, with the buyer's attorney, when that can be dicey at times.
Anthony, I have a question for you. And in the sale of a family business, is there any way to include family members in the non-compete? I assume they mean family members of the seller when they're not the actual seller, but they're a spouse or a child who acted as an employee, but aren't the actual shareholder or owner of the seller entity.
Great question. And the answer is yes. Basically, they can be involved by signing an agreement. I'm saying they, the spouse, the child, whomever. But I will also say that even expanding it beyond family, sometimes it makes sense for the buyer to want non-family employees to sign and not compete. If there is a part of the management team, could be the president who isn't part of the family. It could be CFO, it could be director of sales, etc., along with a child who's an employee. But yes, and that's where, again, it's part of the negotiation where the buyer will say, I will pay you all this money for these assets, provided this group of entities and people sign these covenants to not compete, not solicit, etc. But it would be something that the member of the family and or employee would have to sign. There'd be typically a separate non-compete. What you would have is a condition of closing that that these certain defined list of people sign agreements, or even potentially have them agree up front that they will sign at closing.
If the family member isn't getting any of the money, how is their consideration for that agreement?
Another great question. Again, case by case, but at the extreme, I advise the buyer to pay something for it, even if it's $2,000. It is a question. It's easier when the employee, or at least there's a better connection if the employee becomes an employee of the buyer, potentially. So I can't say it's always true, Andrea, but again, in the extreme situation where there is a good claim, there's no consideration, I'd advise my client, the buyer, to actually pay something more than $10.
And the common law and Mohawk cases where even if the covenant signed by the seller is limited in time, he can't, even after that expiration, solicit where there's sale of goodwill involved. Does that also apply if family members and employees sign a non-compete? Does that apply to them as well?
I can't say I know the exact answer. I don't think so. I think it applies only to the shareholders, the owners who receive the money. I think the idea was that, the seller also, it's not entirely clear in the cases, but it's meant to be the seller and I think the owner who received the money, the proceeds of the sale. But I'm not aware of any case that includes members of the family. Now, apart from that, even if just the say seller shareholder signed a non-compete or non-solicitation covenant, those agreements typically refer to that person, individual, directly or indirectly soliciting, competing. There's always a claim by the buyer that if the spouse or the child is doing something post-closing, calling upon customers, soliciting them, even if the child didn't sign an agreement, that you could argue that's an indirect solicitation by the selling shareholder. I'll jump to Article 9, termination. Again, this is where we have a sign then close. We should spell out under what situations there'd be a termination of the agreement. Again, I think any agreement you sign, you gotta make sure it's not perpetual, or there's no way out. So you try to at least list again, intend to have, again, high level and outside date that if the deal isn't closed by a certain date, you know, maybe 6 months out or something, that there's a termination. So we got about 2 minutes left. Just I'll open up for any last question or questions.
I don't have a question, but I do want to let everyone know that the forms, the attorney affirmation form that you need to submit in order to get credit for this CLE, as well as the evaluation form, are now available on the UB Law website for this particular CLE, and Michelle is putting them in the chat right now as we speak. So I apologize for the delay with respect to that. Jeff Gleason would like to know how it feels to be old.
I will text you later, Jeff, but I wish I was 37, say not 57. And just in closing, I'm gonna get off topic here. It is my birthday, and you start to become more reflective as you get older. I think about my career as an attorney, especially in Buffalo. I want to get on my soapbox right now and say that as I think back upon my career, I think one of the best things I was ever told, the most informative, I think, what's best for you, for your own selfish reasons, and also for, the local community as a whole, community of lawyers. I was told, Anthony, you know what, you can really do a great job for your client. You can be their advocate. You can really get a good result for them by still being professional and not being a jerk. So when you deal with somebody else on the other side, be an advocate, get the best result you can for your client, but treat the other person, the other attorney, with respect, professionalism, and don't be a jerk. And I will say that I think also selfishly that also benefits, you, me, because over time, I think people will treat you as you treat them, and over time, it does benefit you. So at least the extent that this is a profession, it's my birthday again, I'm old, I encourage everyone to maintain professionalism going forward.
Anthony, thank you so much for this presentation, for joining us on your birthday, for sharing your expertise and your wisdom. And I just want to emphasize, I just said that a week ago to a group of students about what to be an attorney and how grateful I am to practice here in Buffalo with excellent attorneys who above all are professionals, and that you don't have to be a jerk to be a good advocate and to be a good attorney. So I appreciate you sharing that. I think it's completely true. And I think Buffalo breaks the stereotype of what a lot of people think lawyers are, or maybe even should be. So with that, Anthony, thank you so much. I hope you have a great day. The sun is out, so you can't beat it. So thank you so much for your time. Thank you everyone for your questions. I won't beat the dead horse about getting your verification and getting the evaluation in. The link is there. So on behalf of the UB Law Gold Group, thank you all so very much for your time today, and we look forward to seeing you at the next event. Thanks so much.
Everyone, thank you. Have a good day.